Hello, everyone, and welcome to another edition of the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 7 of the Forge of Freedom. Today, we're going to be discussing the concept of the presumption of innocence and the importance of this concept to civilized society. But before we do, I just want to tell you a little bit about the podcast. I'm an attorney, I'm a firearms instructor, and a husband with a passion for freedom. At the Forge of Freedom, we believe that freedom is the highest political goal, and we believe that individuals thrive where freedom and personal responsibility coexist. Without a populace that shares a passion for freedom and personal responsibility, the world can quickly devolve into tyranny. And it is our hope that this podcast can help motivate our listeners and those around them to create and preserve freedom for themselves and for future generations. But the task of creating and preserving freedom is not an easy one. Freedom is not given to us by government, and it is not passed on in the bloodstream. Freedom is forged through personal responsibility and continued vigilance. And we want to motivate you and equip you with the knowledge, the skills, and the attitude to develop your body, mind, and soul for the task of living a freer life and creating a freer world. We want you to have the body of an athlete, the mind of a stoic, and the spirit of a warrior. We want you to be the Forge of Freedom. All right, so with that said, once again, I'm your host, Alex Ooley, and this is episode 7 of the Forge of Freedom. So let's go ahead and jump into the topic for today. What is the presumption of innocence? And why is the presumption of innocence so crucial to civilization and to a civilized society? I think many Americans are oblivious to the dangers of imposing the burden of proof or the burden of persuasion upon the person accused of wrongdoing. But I think there's also a logic in how civilized, decent, truth-respecting people assess claims of wrongdoing, no matter how horrendous or grievous the claim or accusation is. And this logic has really two essential components. First, any accuser must have something more than the accusation itself. And second, the accused is presumed innocent of the charge until and unless the accuser makes a reasonable argument that the accusation is true. And this seems intuitive. We follow this logic in our daily lives. Just imagine if you have a 6-year-old child who accuses your 7-year-old child of punching him without provocation. Would you, on the basis of that accusation alone, punish the 7-year-old child? If you did, that would be bizarre and bad parenting, right? We're not doing it on the basis of the accusation alone. Or what if you're a teacher and a student sends you an email telling you that another student cheated on the exam? Do you presume, on the basis of the accusation alone, again, that the student accused of cheating is in fact a cheater? Or that the person accused of cheating is obligated to prove that they didn't cheat? If you did, you would be, in my opinion, a bad teacher. So here again, just two common examples of where we presume innocence. An accusation is not enough, and the person being accused does not have to prove themselves innocent. The fact that children often hit their siblings without provocation, and the fact that students often cheat on exams, neither of these facts remotely justifies you in any of these scenarios as treating the accusation alone as being sufficient evidence of its truth, or to impose the burden of proof on the person being accused. And this basic logical notion is extended to our legal system, this presumption of innocence. And the presumption of innocence in the context of our legal system is a legal principle that every person accused of any crime is considered innocent until proven guilty. And under the presumption of innocence, the legal burden of proof, of proving guilt, is on the prosecution, the accuser, which must present compelling evidence, not just accusation, compelling evidence to the trier of fact, which is typically the judge or the jury. And if the prosecution does not prove that the charges are true, then the person who's being accused is acquitted of the charges. The prosecution must, in most cases, prove the accused is guilty beyond a reasonable doubt. If reasonable doubt remains, the accused must be acquitted. And this is a high burden of proof. We don't want innocent people going to jail, having their freedom taken away on flimsy evidence. In many countries and under many legal systems, including common law, which means law that is formed or created from judges or from cases and controversies that are decided by judges, and civil law systems, the presumption of innocence is a legal right of the accused in a criminal trial. In fact, it's even an international human right under the United Nations Universal Declaration of Human Rights under Article 11. Interestingly, though, the presumption of innocence is not guaranteed under the U.S. Constitution. Nevertheless, there are statutes and court decisions, such as the U.S. Supreme Court case of Taylor versus Kentucky, where this presumption of innocence has been recognized as one of the most basic requirements of a fair trial. It's also derived from the Bill of Rights via the Fifth Amendment Due Process Clause and the Sixth Amendment right to counsel and right to jury trial, and then also via the 14th Amendment, again, through the Due Process Clause of the 14th Amendment. The 14th Amendment, by example, says, in part, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law." And let me repeat that. Nor shall any state deprive any person of life, liberty, or property without due process of law. And it's interesting to note here that the Constitution states only one command twice. The Fifth Amendment says to the federal government that no one shall be deprived of life, liberty, or property without due process of law. And the 14th Amendment, ratified in 1868, uses the same 11 words, called the Due Process Clause, to describe a legal obligation of all states. These words, this due process clause, has as its central promise an assurance that all levels of American government must operate within the law and provide fair procedures, due process. And this presumption of innocence is part of due process and fair procedure. The English jurist William Blackstone, in his seminal work, Commentaries on the Laws of England, published in the 1760s, said that it is better that 10 guilty persons escape than that one innocent suffer. And this idea subsequently became a staple of legal thinking, especially in English or common law jurisdictions in the West, and subsequently was adopted in the United States, which in the United States, the law is largely predicated on the common law from England. Nevertheless, even with this presumption of innocence, which seems intuitive, which seems fair and essential to fair process, as an attorney, I'm often confronted with the question, how could you defend someone who is guilty? Well, it's an attorney's job to develop a defense strategy, not to judge the person being represented. Defense attorneys are ethically bound to zealously represent their clients, even those whom they think will be justly found guilty, as well as those whom they think are factually innocent. A vigorous defense is necessary to protect the innocent and to ensure that judges and citizens, and not the police, not the prosecutor, have the ultimate power to decide who is guilty of a crime. And I represent many indigent defendants. And for personal reasons, I take a lot of pride in doing so. I, along with the jury, am often the only thing standing between my client and the power of the state. Think about that for a moment. When someone is charged with a crime, the case caption or the case title reads, State of wherever you are, in my case, Indiana, State of Indiana versus John Doe. It's John Doe versus the state and all the resources the state has to bear. And the attorney is there to make sure that the individual rights of the defendant are protected and that any verdict is only reached after the facts and the evidence are presented. Furthermore, and in reality, the defense attorney almost never really knows whether the defendant is guilty of the crime that's charged. Even where a defendant says he did the crime, doesn't necessarily make it so. There are instances where a defendant may be lying to take the blame, to take the fall for someone they want to protect, even if they're truly innocent. Or, in another scenario, the defendant might be guilty, but of a different and lesser crime than the one being prosecuted by the state. And this is, I would say, far more common. Overcharging is far more common than most people in the general public realize. A defendant may also have done the act in question, but have a valid defense that would exonerate him, like self-defense, for instance. For these reasons, among others, defense lawyers often do not ask their clients if they committed the crime. Instead, the lawyer uses the facts to put on the best defense possible and leaves the question of guilt to the judge or the jury. And even if the defendant is guilty and the attorney knows or believes the defendant to be guilty, providing a vigorous defense is not necessarily about guilt or innocence of that particular person. It's about protecting the integrity of the process. If the process and protections are not there for the guilty, they will also not be in place for the innocent. Let me be clear, though. A defense attorney cannot lie to the judge or the jury. So where an attorney believes their client to be guilty, they can't say that the defendant did not do something the lawyer knows the defendant did do. The lawyer also can't admit guilt against the client's wishes. Instead, the attorney will focus their trial tactics and arguments on the government's or the state's failure to prove all the elements of the crime. Jean Lemon was a French lawyer and a cardinal, and his work provided the basis for the saying that even God must give the devil his day in court. And this just stems from the idea that God is a just God, and justice requires hearing all of the facts and evidence before making a judgment. Without procedural safeguards, without counsel, without the right to a trial, and without the presumption of innocence, we would be subject to mob rule or trial by media or the dictates of a tyrant, and we would have many unjust results. There are many examples of this mob rule or trial by media, and we can imagine how some circumstances might have turned out if not for the presumption of innocence and the due process safeguards built into our legal system. Think about just a few examples. Think about John Adams, and I think about this in the context of the Revolution and forming a new government and forming, the Bill of Rights and the procedural safeguards. John Adams was essential to that. And you think about after the Boston Massacre, he defied anti-British sentiment in the colonies and successfully defended British soldiers against murder charges. If you're not familiar with this, I'd encourage you to check out, there's an HBO miniseries just called John Adams, and it's a really well-done miniseries, and I think it's actually the first episode or installment in the miniseries that portrays John Adams defending these British soldiers despite the mob mentality and the violence and the yelling that basically tried to lead to a murder conviction where these British soldiers were innocent. Another example that comes to mind is Kyle Rittenhouse and the rioting that was going on after the Jacob Blake incident in Wisconsin, in Kenosha, Wisconsin. And Rittenhouse, he shot 3 men during some civil unrest, and in the media essentially tried to hang him in the court of public opinion by portraying him as someone with violent intent, like he went there with the hopes of engaging in violence. And the media really portrayed Rittenhouse in the worst light possible and essentially tried to effectuate a guilty verdict through the media. But thankfully, a jury of his peers found him not guilty, but only after a lengthy trial and many months of ridicule by the media. I also think about Richard Jewell, and he wasn't actually charged, but Richard Jewell was a security guard and law enforcement officer who alerted police during the Centennial Olympic Park bombing at the 1996 Summer Olympics in Atlanta, Georgia, where he discovered a backpack containing 3 pipe bombs on the park grounds and helped evacuate the area before the bomb exploded, saving many people from injury or death. there was a leak after his heroic act that identified him as a suspect. And the publicity around this leak and the identification of him as a suspect ruined his life for many months. And although he was never charged, he underwent this trial by media, which took a tremendous toll on his personal and professional life. He was eventually cleared after having been a suspect for 88 days. And in 2005, Eric Rudolph confessed and pleaded guilty to the bombing. So here's an example where he wasn't charged, but Richard Jewell was seen in the eyes of the media and the public as having been guilty, and there were these calls for punishment before a trial, before he's even charged. Of course, one could think of many counterexamples where someone who seemed guilty was acquitted and let loose, but here's the important point, and it takes us back to the quote by William Blackstone, which I'll reiterate here again. It is better that 10 guilty persons escape than that one innocent suffer. Everyone is entitled to life, liberty, and the pursuit of happiness. And life, liberty, and the pursuit of happiness cannot be taken away without due process, without facts and evidence. Guilt by mere accusation, by mob rule, or by trial by media is not fit for civilized society. Think about this for a moment. Imagine you are behind a veil of ignorance. You do not know if you are a good person or a bad person, and you do not know if you will be accused of a crime once you step into the world from behind the veil of ignorance. Whether you are a good person or a bad person, I believe you would hope that you are stepping into a world where there is a presumption of innocence and where there are procedural safeguards to promote that presumption until you are proven guilty. With that thought, I'd like to finish by sharing two quotes with you, one from John Adams and one from Voltaire. And I'll start with the one from Voltaire. And this is a lot like the one from William Blackstone. It is better to risk saving a guilty person than to condemn an innocent one. And then the one from John Adams. It is more important that innocence be protected than it is that guilt be punished. For guilt and crimes are so frequent in this world that they cannot all be punished. But if innocence itself is brought to the bar and condemned, perhaps to die, then the citizen will say, whether I do good or whether I do evil is immaterial, for innocence itself is no protection. And if such an idea as that were to take hold in the mind of the citizen, that would be the end of security whatsoever. So with that, thank you for tuning in. And if you like what you heard today, don't forget to like and subscribe. I look forward to talking with you again next week when we will discuss civil asset forfeiture, which is the often abused practice of taking property of someone accused of a crime and often without having a conviction. Until then, remember, you are the Forge of Freedom.